All right, welcome to Module 4. We're still in week 2, which is, again, a tough week because we're dealing with some very important and complex issues. Last module, we focused on the Constitution. This module addresses in greater depth one of the more consequential constitutional principles, which is federalism. As we discussed in the earlier presentation, federalism is a system of government where power is divided between a national government and smaller constituent state governments. In this module, we'll learn about the advantages and disadvantages of that kind of a system, how American federalism has evolved over time, and the kinds of key issues that tend to draw the federal and state governments into conflict and where they actually also need to collaborate in order to get good policy. A good way of thinking about the key difference between unitary, federal, and confederal systems of government is to track the flow of sovereignty, right? Where does the authority granted by the people through popular sovereignty, where does it flow? In a unitary system of government like France's, for example, sovereignty flows from the people to the national government. And any inferior governmental entities are frankly creatures of that national government. In a confederal system like the European Union, the states retain sovereignty. So sovereignty flows from the people to Germany, France, the other EU member states, and the power of the EU government overall is sharply curtailed. A federal system like ours has this sense of dual sovereignty, where citizens of the states are also citizens of the United States, and the federal government has considerable resources to use to govern. So the Constitution designates certain tasks to different levels of government. For example, the federal government has exclusive authority to coin money and to regulate the value of money, because allowing states to have their own currency would inhibit economic growth. Likewise, the Constitution reserves to the states certain powers, such as administering federal, state, and local elections. However, Article 1, Section 4, which designates that authority over elections to the states, also states that Congress may at any time, by law, make or alter such regulations, except as to the places of choosing senators. So additionally, ratification of the 14th Amendment empowers Congress to regulate states' actions to ensure that they're not discriminating against segments of their populations. The power of the federal government to regulate the states is somewhat constrained by the 10th Amendment, which contains the Reserved Powers Clause, basically saying that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. There are several areas where there are ambiguities in the division of power. Issues like marijuana legalization, gay marriage, and healthcare administration and immigration have all proven to be areas of contention between the federal government and state governments. An important aspect of any discussion of federalism is this idea of intergovernmental relations, and that again refers to the interactions between the different levels of government, right? When IGR is working well and everyone is on the same page, then the relationships are collaborative and generally they produce good results. When there is disagreement at the different levels of government, the relationships are more adversarial and often produce bad policy and dysfunctional government. Very often conflict results in coercive policies being forced on the lower levels of government, which is often derisively described as crammed down federalism. The main areas where the federal and state governments act in concert or conflict will include education, road construction, Medicaid, elections, and prisons. To illustrate, the federal government began issuing grants to state governments for road construction in the early 20th century, recognizing the explosion in car ownership. Over time, the federal government began offering matching grants to state governments as incentives to invest in road construction. So the relationship between the federal and state government is largely cooperative in that sort of issue because it's a win-win kind of situation. The federal government provides funding for interstate highways, and the state and local government authorities are responsible for maintaining access points to the highway and for policing the roads. I say it's a win-win situation because, again, both federal, state, and local government benefit from building and maintaining roads simply because it increases economic productivity. So federalism is designed to prevent the concentration of power and ultimately to maximize individual liberty. However, federalism can have negative effects as well. For example, the likely decision of the Supreme Court to strike down the decision in Roe versus Wade that legalized first-term abortions mean that women who experience an unwanted pregnancy will have profoundly different outcomes in states like California than they will here in Oklahoma. Likewise, I think it's fair to say that children who attend schools in affluent neighborhoods are almost certain to have access to dramatically better education than students who attend schools in inner city or rural schools for a variety of reasons, mostly related to poverty. An important consideration for understanding federalism is the distinction between enumerated and implied powers. Enumerated powers are those clearly articulated in the Constitution, and an example of an enumerated power is the president's authority over the military as commander-in-chief. In contrast, an implied power emanates from Article 1, Section 8's necessary and proper clause, which empowers Congress to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, the powers that are enumerated in Article 1, Section 8. And all other powers vested by this Constitution in the government of the United States or any department or officer thereof. In other words, again, it's what is described as the elastic clause, right? An example of an implied power was Thomas Jefferson's Louisiana Purchase. The acquisition of new territories was not mentioned in the Constitution, but Jefferson persuaded Congress to ratify the purchase and the payment of $15 million in 1803. Another complicating factor for understanding American federalism is the legal status of Native Americans. Under U.S. law and resulting from treaties signed between the individual tribes and the United States government, Native Americans are viewed as domestic dependent nations. As a result, they have the status of federal citizens, and enrolled tribal members can't be tried in state courts for crimes committed on tribal land. This was the result of a Supreme Court decision that dealt with the McGirt decision that dealt here in Oklahoma. That has placed significant burdens, for example, on the FBI operating here in Oklahoma, because a lot of crimes that previously had been prosecuted in state courts now have to be brought before federal courts, federal district courts. So we've established that the federal government has enumerated powers and the state governments have reserved powers. But federal and state governments also have concurrent powers, which refer to powers that both the federal and state governments have. An example of that is taxing authority. All levels of government have the authority to levy taxes on their citizens. And that's simply logical. Governments that cannot fund their operations are not governments. Another aspect of federalism are the constitutional principles designed to facilitate interstate commerce. This is often described as horizontal federalism. An example of horizontal federalism is Article 4's full faith and credit clause, which basically states that states have to acknowledge and accept the public records, acts, and judicial proceedings of other states. For example, I earned my doctorate in South Carolina, but I was able to find work here as a professor in Oklahoma. If Oklahoma didn't respect South Carolina's educational degrees, then I would only have been able to look for a job as a professor in South Carolina. I hope you can see how that would actually inhibit, again, economic movement and productivity. Another clause in Article 4 is the Privileges and Immunities Clause, which requires that states treat visitors and those moving to the state in the same manner that it treats established citizens. Individuals' rights to interstate travel is protected by this clause. Federalism can lead to policy innovations where one state adopts a new approach to a problem, and if it succeeds, that policy will often be adopted by other states. Associate Justice Louis Brandeis coined the term laboratories of democracy to capture this advantage to a federal system of government. The text illustrates policy diffusion by looking at the spread of marijuana legalization throughout the states. Today, 21 states, including Oklahoma, have legalized medical marijuana. and 12 states have legalized both medical marijuana and recreational marijuana. Only 18 of the 50 states at this point have not acted to at least legalize medical marijuana. The disadvantage of federalism is that if states can act as laboratories of democracy, so too can they act as laboratories of tyranny. Just as states innovate in healthcare or education policies, so too can states innovate in suppressing the rights of some segments of their citizenry. Examples include black codes that were passed down immediately after the Civil War that denied black Americans basic political rights. Today, you have strict voter ID laws where, once adopted in one state, they're oftentimes adopted, through, by governments with like-minded majorities. The same can be said, I think, of the state laws banning abortion. Again, these are mostly lower population states, mostly dominated by conservatives. The text also describes the role of the courts in expanding the rights of citizens through the process they describe as judicial federalism. Judges often rely on state constitutions to issue rulings that grant citizens greater rights than those offered by the federal government. I would also note that if judges can expand freedom, they can also restrict individual rights. Partisan conflict has often crept into judicial decisions as well. Conservative judges at both the state and federal level have issued rulings that have undermined the guarantees of environmental protection and protections against discrimination based on sexual orientation. Of course, we're going through a round of this kind of litigation resulting, from transgender conflicts. Florida's Don't Say Gay bill is a classic example. Before closing, one of the reasons why students struggle with federalism is that the meaning of federalism has changed at different times. Largely, changes in the meaning of federalism have involved significant changes in the judicial interpretation of that constitutional principle. But it's also a political issue, and political branches of government have sought to expand their power to respond to challenges, and other interests have pushed back in the attempt to retain greater authority for state governments. So you have distinct eras in which the judicial meaning of federalism meant something very different than in different eras. I want to just briefly touch on these distinctive areas of federalism and how judicial interpretation influenced the powers available to the federal and state governments vis-a-vis one another. From 1790 to 1865, the dominant interpretation of federalism was what we call dual federalism. That actually really endured well into the 20th century. Metaphorically, it's described as kind of layer cake federalism. Within this interpretation, the national government and state governments exist in entirely separate zones of sovereignty, and the federal government has very little ability to regulate the behavior of the states. This, again, reflected a neglected aspect of what we might describe as the American experiment in democracy. At the time of ratification, the Constitution created a political regime in which two experiments were running on parallel tracks, and there was no hint of democracy at the time. You have an emerging, kind of nascent capitalist North and a straightforwardly authoritarian South, whose economy and society was organized around the institution of slavery. From 1865 to 1937, there was very little change in the formal interpretation of federalism, but the Constitution itself was thoroughly revised to close off the resort to Republican authoritarianism by ending slavery, extending the right to vote to black men, and through the ratification of the 14th Amendment, which marks the most thoroughgoing reform of our Constitution by extending to citizens of each state federal citizenship and empowering Congress and the federal courts to ensure the equal protection under the laws. The challenge was that the federal judiciary declined to see the implications of the Civil War amendments to the Constitution and continued to interpret federalism very narrowly. In 1937, the meaning of federalism changed significantly, with the Supreme Court dramatically reversing itself and holding a number of New Deal programs constitutional where they had previously struck them down as violations of dual federalism. This dramatically expanded the federal governments to combat the Great Depression. We call it today cooperative federalism, largely because the federal government was taxing enormous amounts of money and just pumping it into the states to try and combat the Great Depression. And so, you had the federal government dramatically expanding its taxing authority and dramatically expanding both grants, but also expanding the federal government's regulatory authority eventually over the environment and civil rights. Several different interpretations of federalism emerged since the end of World War II. During the 1960s, the Johnson administration resorted to what was known as cooperative federalism to implement its Great Society programs, bypassing state governments to deliver programs directly to local governments and to private entities because they believed that southern state governors would simply oppose those programs or deliver those benefits solely to white inhabitants. In 1980, Ronald Reagan, in his first inaugural address, declared that government is not the solution to our problem, government is the problem, proposing a comprehensive what he called a devolution revolution that would return power to the state governments. And of course, since the 1980s, federalism has continued to be interpreted in various ways, with conservatives preferring to devolve power to the state level or to privatize powers altogether, and liberals preferring national solutions to big problems like poverty, education, and healthcare. So there's a lot more to this, this chapter. Again, in closing, if there are lots of issues addressed related to federalism that I haven't addressed. If there's anything that you find confusing, again, please let me know in the weekly discussion.